Hello, my name is Robert Walker, accountant and insolvency practitioner, and this is the fourth in my series on the subject matter of managing insolvency in troubled times. In this session I'm going to outline the alternatives to compromise, which is what this series is about. There are four such alternatives: liquidation, receivership, voluntary administration, and informal arrangements with creditors. In this session I'm going to deal only with liquidation, as it's a broad subject, and I'll deal with the other three in the next session. Liquidation. Okay, liquidation is a very complicated business. It occupies one whole part of the Companies Act to itself, but its tentacles spread across the Companies Act, as I've explained before. The purpose of identifying a few features of liquidation in this session is so that it enables people to contrast it with compromise as a process of dealing with insolvency. Right, what is liquidation? Liquidation is the process whereby a liquidator is appointed, and they can be appointed in one of two ways, primarily by shareholders or by a court at the petition of a creditor. Increasingly, the pool of people from whom liquidators can be drawn will be a regulated class of people, but the statute has for some time required independence in the liquidator. So it was always basically the case that liquidators were to be objective and independent when they undertook their work. Okay. The most important thing to understand at the outset for directors is that the effect of liquidation is that a director is disempowered. They no longer have any powers other than those powers necessary to comply with the requests of liquidators, such as provision of records and such like. Okay, what is the primary duty of a liquidator? The primary duty of a liquidator is to realise assets, collect in the assets, and distribute them in the order of priority set out by statute or contract until such time as the assets are exhausted, and if there's anything left over, which there won't be with an insolvent company, and distribute that to the shareholders. What do liquidators actually do? Well, they go around and pick what I call the low-hanging fruit. Okay, they go and they sell inventory, machinery, collect in debtors, collect cash, sell liquid assets and such like, providing of course those assets aren't already in the clutches of secured creditors, and almost invariably these days most of them will be. What a director needs to be concerned about is invariably when there is an overdrawn current account, meaning that a director shareholder has put in less money than they've taken out, the sum of money being the difference will be claimed by the liquidator almost invariably. Indeed, the liquidator is obliged to do that. Because liquidation is complex and is carried out by expensive professional people, not just the liquidator but also lawyers who advise them, it can be very expensive. Professional fees cause significant sums of money in liquidation to be spent on professionals. But that's not the only reason liquidation can be expensive. Liquidators can't afford to dither. They must be in and out relatively quickly. They can't necessarily afford to run a business, so assets get sold at fire sale prices. That affects their value. It reduces the value of assets significantly if they have to be realised on the spot. Now, it is true that liquidation does not necessarily entail the death of a company or its business. Liquidators indeed can invoke compromise. There is a relatively recent power for liquidators to do a hive down, which is to take the intact business, take it out of the existing company and put it into a new company with the approval of the creditors, of course. Those things are actually expensive to carry out if it's in the hands of a liquidator. They're not likely to happen, but they're theoretically there. There are also other assets in liquidations, which I will call ambiguous or complex assets, and I've mentioned those from a different perspective in the episode on the perils of inaction. And those are lawsuits against directors for breaches of duty or failing to keep proper accounting records, or extend beyond that, invalid distributions, avoidance of contracts with directors and so on. Okay, they could collect money from that. Frequently they won't do that, and indeed they are obliged to unless they do certain things. Invariably they don't, but they can escape the obligation to take those actions. Now, in the past, and there's been much amendment to the Companies Act to try and prevent it, there has been the phenomenon of complacent liquidators, complacent with an S rather than a C, in other words debtor-friendly liquidators who are appointed to protect directors. That increasingly doesn't happen because of regulation and these amendments that have been made. So if a director thinks they're going to find a person who will do that for them, they might be sadly mistaken. Now, the other thing to notice about liquidators is that the ban in the common law on selling lawsuits, causes of action, doesn't actually apply to liquidators, and indeed Parliament, probably 15 years ago, emphasised that it should be done by specifically empowering liquidators to sell actions that belong only to them. So it's encouraged, in other words. Now, it may well be the case that liquidators don't take the actions that I have described. However, that doesn't mean to say that directors will be exempt from potential consequences of running an insolvent company. Now, as I've said before, liquidators have an obligation to report criminal conduct. What that may entail is, if it was reported, is that the Registrar of Companies may well ban the director because they have been specifically empowered with the right to do that, as have the courts. So even if you escape pecuniary consequences of delinquent conduct by running an insolvent company, you may well find you're not allowed to be a director for a while. Now, there's one last area I wish to address within the context of liquidation, because it in actual fact interacts with compromise in a rather interesting way, and that is the subject of what I will label under the rubric unfair preference. Now, we've discussed this before. Indeed, you can see that it is present in the National Bankruptcy Act. It was in the mind of Madison when they formulated the Constitution in the United States the way they did. But it predates the Founding Fathers by some centuries. The first time that it was ratified in law was in the Fraudulent Conveyances Act of 1571. In other words, it has been a long historic phenomenon that insolvent debtors will try and divert the residual assets to their own benefit or the benefit of their creditors, and those actions can be undone. It's called voidance, meaning it is as if it never happened, and any money that has been paid can be drawn back in. An example may well be that a director has given a personal guarantee to a creditor. That director has an incentive to pay that creditor in such a way that it would be unfair on the other creditors. That money can be clawed back in and put into the pool for all of the creditors. In other words, significant uncertainty prevails when a liquidator is appointed with respect to a whole series of transactions. Now, I will deal with unfair preference in more detail at a later date, but it does have rather an interesting consequence, doesn't it? In that it can only happen when there's a liquidation. If there is a liquidation, it can happen, but if there's no liquidation because there's a compromise, it is forestalled. It may still happen at some future date because a compromise can be the basis for the company being put into liquidation, but it certainly postpones it and probably eliminates it if the compromise is successful. So that's one of the main points about compromise, is these terrible consequences don't happen. Liquidation can be traumatic, destructive, psychologically draining for those people who get caught into it. That in itself should provide an incentive for directors to arrange things in a different way, to avoid those consequences and hopefully preserve the value of the assets for the benefit of the creditors. Indeed, attempting an honest compromise, because sometimes they're not, is a way of a director showing that they have taken cognizance of the interests of the creditors and tried to do something about it. Please, if you wish for written material, look below the video and you will find ways to acquire it. Thank you very much. Bye.